I appear for the state response.
I appeal for the petitioner, my lord.
Yes, Mr. Majumdar.
My lord, though the matter has come up for hearing, but my lord, we had a discussion with the petitioner. We find that at this stage, it may be appropriate to exhaust all the statutory remedies. And my lord, all the points to be kept open so that we can come back to your
Right.
lordship with all the points.
So you want to withdraw this writ petition with liberty to move the appropriate authority?
Yes,
Is that
yes,
so?
Yes, yes, yes.
And we'll keep all
Points open.
happy. I'm also happy.
Yes, Your Lordship.
Appropriate authority.
Good. Learned senior counsel appearing for the petitioners, on instruction, submits that the petitioners seek to withdraw the present writ petition with liberty to approach the appropriate authority, statutory authority, for the self-same reliefs on similar grounds. Which of next para? In such view of the matter, WPO 907 of 2026 is dismissed as withdrawn with liberty to the petitioners to move the appropriate statutory forum with a challenge against the self-same order on the grounds
subsequent orders. My lord, kindly
on the
take it.
self-same order as well as subsequent orders, if subsequent connected orders, if any,
We will exhaust all
on the
remedies and-
self-same grounds as taken in the present writ petition as well as further grounds, if the writ petitioners so deem fit and proper. Full stop.
Yeah.
It is made clear that all questions raised in the present writ petition by both sides are kept open for being decided before the said forum, if such a challenge is filed. Full stop. Interim orders, if any, stand vacated. No orders to cause unnecessary copies.
Wait, wait.
Lord, I
Stamp Act.
Yes, we will see you.
So, my-
other day, I met Mr. Upadhyay, Lord, and we speak about cases even outside court.
Obviously, yes.
So I said that, are you seriously going to pursue that? I get back to you, Dada, with instructions.
That is the difficulty, Mr. Chaudhary. So much depends on counsel, fairness of counsel, and the litigant's fate depends on the counsel also so much.
Right.
I mean, we every day after coming this side, I wonder all the more.
Now, my Lord,
I mean,
now he has not incurred the liability of hydrating me.
But this withdrawal itself is hydration.
Lord, I appear for the state.
thank you. Yes,
wait for my.
thank you. Thank you, Mr. ঠিক আছে এবার তোমার হাত just শুরু কিছু নেই দেখে দাও বোর্ডে আগে দেখানো হোক, তারপর দেখো আগে বোর্ডে দেখানো হোক, তারপর দেখো
My lord, I am appearing for the petition.
yes
And on last occasion, that is on 3rd July 2026, my lord was pleased to issue rule against the Alice container, my lord.
yes they had the contributors had probably appeared before the registrar. They have recorded their presence.
Contemner has also complied with my lord's direction.
Complied, achha. Are they present today by any chance?
No, my lord. They
Need not. We did not direct them. No, if necessary only. So, what was the nature of the order which was to be complied?
kindly takes the
It comes
order at page 20,
page 23 of the
27.27 of the contempt petition.
Yes, the ordering portion.
Order paragraph 4 and 6.
Just give me half a minute. I'll just. So, up to what stage you have given hearing and decided it?
My lord kindly takes my report that was filed on 24th July. My lord kindly takes point number 7 and 8, my lord. After obtaining all authenticated land records and supporting documents, the executive engineer submitted the matter before the Honorable Subdivisional Magistrate Tomluk, requesting initiation of proceedings under Section 3, Subsection 1 of West Bengal Public Land and eviction of unauthorized.
So we have seen you have given hearing, you have passed a final order. During preparation and execution of that, you found that an appeal has been preferred against the parent order. So that's not your fault. Yes, they've complained.
My lord.
So you're dropping the contempt? Thank you.
Grateful, my lord.
From the compliance report filed by the alleged contemner, comma, dated July 24, 2026, comma, it transpires that, comma, pursuant to the order of this court dated April 4, 2024, passed in WPA 13850 of 2023, comma, the alleged contemner has, comma, upon giving appropriate hearing and on the materials before him, comma, disposed of the representation given by the writ petitioners, and upon conclusion of the proceedings, comma, passed a final order dated May 27, 2025, directing removal of the unauthorized constructions concerned. Post of next para. However, comma, during preparation and execution of the demolition order, comma, the subdivisional officer inspected the site and found that unauthorized structures were connected with live electrical installations, and consequently, the station manager, comma, WB ACDCL, comma, Panchkura power station was requested to disconnect the electricity supply to facilitate safe demolition. Post of next para. From the report, comma, it further transpires that in the meantime, the private respondents preferred appeal case number 18 within bracket AO bracket close of 2025 under section 7 of the West Bengal public land within bracket eviction of unauthorized occupation, unauthorized occupants should be occupants bracket close act, comma, 1962 before the district magistrate, comma, Purbo Medinipur, comma, challenging the order dated May 27, 2025, passed by the subdivisional magistrate. Full stop. Next para. In the said appeal, comma, an interim order has also been passed and the appeal remains for adjudication. Full stop. Thus, comma, upon a perusal of the said report, comma, it is evident that the alleged contemner has fully complied with the order of this court. Full stop. The subsistence of an interim order passed in appeal operates as impediment to the alleged contemner to proceed with the demolition of the unauthorized structures, and, comma, as such, comma, the alleged contemner cannot be made liable for the same. Full stop. Thus, comma, in view of the order in question having been complied with, comma, rule was issued.
Rule was issued, my lord.
Yes, my lord.
Rule that may
My lord, 3rd July 2026.
WPCRC number 166 of 2026 stands discharged, and CPAN 742 of 2025 stands disposed of. Full stop. Urgent certificate.
I'm grateful.
Grateful, my
Thank
lord.
you.
Grateful.
My lord, item 2 to 20, my lord, I'm appearing for the licensee company, my lord.
Yes.
Respondents, my lord. My lord, last occasion, my lord, we submitted before, my lord. My lord, I'm led by Mr. Rajashri Dotto
Lord, I am for the petitioners in this matter.
Yes.
through virtual mode, my lord. My lord, on the last occasion we had submitted, my lord, there's a Supreme Court order which is pending because there was no coercive steps were supposed to be directed by were to be directed by Supreme Court. My lord, this was the order of 23rd of March 2026. My lord, this matter, my lord, this
In
particular
connection with
proceedings.
different.
No,
different-
my lord, this
My lord,
period.
similar issues are involved in
yes,
these matters.
different
also.
matter, but similar issues are.
Yes, my
that
lord.
is
My
what
lord, we had submitted, my lord, because of this pendency of this particular observation by the Honorable Supreme Court, my lord, subject to my lord's kind consideration, if the matter can be postponed to some other date. My lord, let it be 3 weeks after, my lord.
My lord, maybe in the September monthly list.
Mr.
And my-
Chakraborty, we are. I am just putting it out of the list with liberty
My-
to mention, because
my
this has been assigned to me, so I will have to take it up. So
my lord,
whenever
it's a part-hard
my-
matter. It is not
if
an
my-
assigned matter. Part-hard.
part,
Subject to
whatever.
my lord's kind consideration, if it can be on the second week of September, my lord, so that,
Again, a time.
my lord, because the Supreme Court is hearing, my lord, kindly keeps it
We-
if we'll
we
take
are-
adjournment for 2 months then after
Let me
that.
be candid, because this bench is sitting only for these matters.
Yes, my lord.
So if I direct on a particular date, if there is no other matter, I'll have to sit for this matter only, thereby disturbing the regular bench.
No.
So that will be unnecessary. Whenever you mention, we'll take it up.
Absolutely, my lord. We are the petitioners, my lord, it is. And
Yes,
my
yes.
lord's order is under challenge. My lord's one of the orders is under
Oh,
challenge.
then definitely. The court is informed that a challenge preferred before the Honorable Supreme Court against the order under contempt and other orders where similar issue is involved is now pending before the Supreme Court. Now, full stop. The said matters are now pending before the Honorable Supreme Court. Full stop. Next para. In the said matters, comma, the court is apprised that the Honorable Supreme Court has been pleased to pass an order restraining coercive action being taken in terms of the impugned orders. Full stop. Next para. Thus, comma, for the sake of judicial propriety, comma, let the matters go out of the list for the present, with liberty to the parties to mention for enlistment as and when the the challenges pending before the Honorable Supreme Court are disposed of.
Well, there is no contempt, my lord. Subject to correction, there is no contempt. So,
Did I say contempt?
No,
Yes.
my lord, that is not spelled
Yes.
out in contempt, my lord.
subject to correction, my lord, possibly, my lord.
But
said
the
contempt.
we
That's all.
oh,
Oh, acha, acha, yes, yes.
Yes.
Against the parent order. Order under contempt, parent order. Parent order.
Grateful. Grateful.
Thank you. Yes. ঠিক আছে, কি করছি? রাত্রে বল। পড়াশোনা আছে। Yes.
And I appear for the respondent, my lord,
Agwin Nirmalu.
in this.
Nirmalu Agwin. Mr. Sanyal is on leg sale. Lordship. He
Who is
requested
in?
Mr. With Sanyal. He requested me that he will take time.
So then I'm adjourning for the
Lordship. Because
adjourning for the day, Mr. Dasu.
Lordship.
On the of learned counsel for the CSC, comma, let the matter stand adjourned for the day.
Lordship.
My lord, only my lord, next Friday, my lord, only my lord, one request. My lord, only one request, my lord.
I'm appearing for the applicant lawsuit. As per lawsuit direction, this is supplementary affidavit in connection with the section 5 application.
আচ্ছা।
Also, I am for the opposite party.
Copy already served loss.
Very. Now, what is the delay? Period of delay?
So, 119 days delay that was not clearly expressed in the section 5 application.
right.
Because of that reason, lawsuit directed me to express
What is the explanation given in the supplement?
supplementary affidavit. Date-wise explanation I have given lawsuit.
What is the nature of the explanation? Tell me that. After writing, you have forgotten.
Yes, lordship. 17 to December, when I went to give the notice to the advocate who is appearing on behalf of the petitioner,
Yes.
lordship, he told me that the matter was disposed of.
What was your advocate doing? What were you doing when it was disposed?
Thereafter, I communicated this
What is the reason for your being absent on that relevant date?
because lordship, this is a miss.
Missed in the list.
Because of the clerk of the advocate lordship, clerk of my clerk missed the list lordship. Due to that reason, this has been
So
done.
whenever you came to know, whenever you went to give notice to him, you learned. And after that, how much time did you take to file this application? After
Only
learning,
19 days delay.
when you learned from him that that matter has been disposed of, how soon after that?
Lordship, what happened? I collected the server copy of the order where it is found that the written notes of written
How soon
statement
after
was
that?
not
How soon after that did you file this application review?
total delay that has been happened, Lordship.
Don't you understand my question?
Yes, Lordship.
You say you subsequently came to know when you tried to give him notice, and then you checked up the server copy. When did you check up the server copy, and after that, how much time did you take to make this application? If you get the server copy today and file it after 6 months, then that's not an explanation. That's what I'm asking you. Can't even write a section 5. Don't take it so casually. Section 5s are nowadays we are stricter.
Lordship, I clearly expressed in my para T, Lordship, A, B, C, D.
Giving para 3,
Para starting from
Yes, what do you say?
it, Lordship kindly see supplementary affidavit at page 2 of the supplementary affidavit,
Yes. Yes.
paragraph A, 3A.
Yes.
This letter that 17/12/2025 learned advocate for the petitioner of the review application wanted to serve a notice upon the learned advocate of the petitioner in serial number so and so regarding mentioning the matter for early hearing. This letter has not been served at all.
No, he says that
He
you
says-
did not receive because it has been
He
disposed of.
says, my lord, he says, but it was not at all, concerned clerk not at all come to the learned advocate, never served. This is, I am objecting, my lord. This is objecting. Thereafter, my lord, in the trial court record from 8/1/2026, the date is fixed for awaiting order from the honorable. Both sides filed their respective lawyer Hajiral, 20 files copy of the High Court order. Let this same be kept with the CR. It appears from the order of the Honorable Court in CO number so and so that Honorable Court has set aside the order dated 5/12/2020 for local inspection. It is dated 8/1/2026 and review application filed on 20th February 26. Therefore, the delay which when I trying to explain before your lordship, it is not cogent, my lord.
When was the order under review passed?
Why it is past 24th September
Total
2025.
delay is 119 days, lordship.
24th
I have
September
clearly expressed in my
2025, my lord.
supplementary affidavit starting from para 3, lordship. My clerk
After-
going to give the notice to the Jahangir Hossain, who is the advocate on record of the CO application, lordship. He did not receive that and told me that the matter was disposed of. Due to that is the lordship, I collected the server copy and I got the information that the on the basis of the suppression of the fact, lordship, written statement was submitted before the court below long ago, but before the honorable court, lordship, it was submitted that the no written statement was submitted, and it is reflected in the lordship order para 6.
We're allowing this section.
My lord,
I'll allow this section.
my lord, the lordship kindly see 24 September 2025. After 154 days, 20th February 2026. Long delay. The ground which has been agitated in the application is not at all cogent, my lord.
You are taking that into
Matter
account.
was disposed of order passed by your lordship.
The present application has been filed for condonation of delay in filing the review application. First of next para. The supplementary affidavit filed by the petitioner today be kept, review applicant today be kept on record. First of, upon a composite reading of the said supplementary affidavit and the application for condonation of delay, comma, it transpires that as per the averments made therein, comma, after the impugned, when the impugned order was passed on September 24, 2025, comma, the clerk of the learned advocate appearing for the review applicant at the relevant juncture, comma, who was looking after the matter, comma, missed the list, and as such, the review applicant could not be represented on the relevant date. Subsequently, on December 17, 2025, comma, when the learned advocate for the petitioner wanted to serve a notice for early hearing on the learned advocate appearing for the opposite party hearing, comma, the latter informed the learned advocate for the review applicant. The latter refused to receive such notice and informed the review applicant's advocate that the civil divisional application had previously been disposed of. First of thereafter, comma, server copy of the same was obtained and certified copy was applied for. First of, in the interregnum, comma, the review application was drafted. First of, however, comma, the review applicant resides at a village in the district of Birbhum, and due to high fever, he could not come to Kolkata on between 3rd and 5th of February 2026. First of, after recovery, comma, he contacted his advocate, and thereafter the review application was finalized and ultimately filed on March 24, 2020. March 20. No, on February on
Filed on my lord, February 20.
February 2025.
Yes,
February 20, 2026. Whose next para learned counsel appearing for the opposite parties argues that the statement made in paragraph number 3 within bracket small a of the supplementary affidavit, comma, to the effect that a notice was sought to be served on the learned advocate for the opposite parties has not been established and is denied. Even thereafter, comma, it is submitted sufficient explanation for the delay in the interregnum has not been properly explained. Full stop. Next para. In a condonation application, comma, day-to-day delay need not be explained in full particulars. Full stop. However, comma, the entire period of delay has to be properly explained. Full stop. Upon a consideration of the application for condonation and the supplementary affidavit thereto, comma, the court is satisfied that sufficient plausible reason has been furnished for the delay in preferring the application in the light of the narrative above. Full stop. Next para. Moreover, comma, no malafidis can be attributed to the review applicant for the said delay. Full stop. Next para. Thus, comma, can 1 of 2026 is allowed on contest, thereby condoning the delay in preferring RVW 52 of 2026. What is the review about? What is the ground of review? Mr. Chakraborty, you are appearing in the matter?
Yes.
He's behind you, that's why Yes, Mr. Chakraborty, what is the ground of review? We have allowed the condonation. What is the ground of review?
Ground of review, my lord, kindly come to paragraph 6 of your lordship's order.
The review was, the order was passed in respect of a local investigation.
In respect of a local.
It was rejected by the trial court, I allowed, or reverse?
Yes, yes.
Para 6, yes. Mr. Chakraborty. Specific, in the absence of any specific challenge to the identity.
Yes. And it was submitted before your lordship that no written statement was filed.
Yes.
But the party who submitted it, they themselves find the written statement. Kindly come to my application at page 23. The application for
local investigation was granted by the trial court.
Actually, my lord,
and I had set aside.
One local investigation was granted, but that learned advocate commissioner opined that it is a dispute relating to encroachment, that I failed to demarcate where the adjacent plot ends and where the other plot starts. Now,
so you had filed a written statement?
They had filed the written statement.
They themselves have filed?
They have filed. It is page 33. Kindly come to order number 16 dated 10th February 2023. It was recorded by the...
Page number is of the can 2?
Can 2.
Page 33?
Page 33. This is the order number 16 by which such filing was recorded.
Yes. Have you annexed that written statement, Mr. Chakraborty?
Written statement is annexed.
Otherwise, how do you know if there was a dispute raised regarding this?
It's a copy of the written statement.
My order recorded not only that no written statement was filed, I had recorded that in the absence of any specific challenge to the identity, since they have
yes, it is there. It is there. Kindly come to page 40.
Yes. Otherwise, we don't know whether that identity.
No. It is page 40, title suit number 130 of 22, paragraph 6. Kindly come to last 3 lines.
Yes.
The existence of masjid is also denied.
Masjid is denied, yes. নালিশি দাগে অন্য শরিকগণের বাড়ি রহিয়াছে.
That is the point of dispute.
Yes. And the suit was the plaint. What was the relief claimed in the plaint, Mr. Chakraborty?
In the plaint,
your suit?
My suit is against the allegation of encroachment.
Have you got a copy of the plaint by any chance?
Yes.
Might have been there in the main review, but it's not before me right now.
I'm trying to search out the plaint. Before that, your lordship, kindly come to page 13 of the application.
Yes, I'm looking at that, the report.
Yes. There is a portion generally called court in front of the residential house yard. Local people admitted that there is a masjid, but the exact boundary line could not be denied. It's a key.
Original application.
Have you got a copy of the revisional application, either of you? The main revisional application there must have
In
been
the
annexed.
main revisional
18.
application,
18, my lord. Page 18, revisional application.
Thank you.
from page 16, the plain starts, copy of the plain starts.
Acha. Let me check that up. Page 16.
From page 16, the copy of the plain actually starts from page 16.
No. In my copy, no.
CO number 342 of 2024.
Page 16 of the CO.
The 16 of the
CO, I don't have the copy. Yes, now I have.
suit for declaration with consequential relief.
Let me see.
Kindly come to page 20, where the prayer starts. First prayer. Declaration is prayed as to existence of masjid.
Yes, in fact, they had annexed it. I had missed it out. They had annexed the written statement there also.
Yes.
But I proceeded on the basis that there was no written statement. So this is apparently an error apparent on the face of it. Let me see just the local investigation points. The application must have been annexed.
That is annexed to our application.
Yes, it is. Divisional application also is there. Yes, what do you say? I was wrong. Fully wrong.
No, I am not saying so, my lord.
No, I am saying so.
Your lordship has passed order.
I was obviously,
Oh, I
it's a
can see
perverse order. My
Passed order wrong.
No, I recorded on the basis that the
No,
no
that-
written statement was,
that-
it was annexed to the revisional application.
That is my lord true in
I'll recall and allow the local investigation. I'll dismiss the revision.
local investigation.
The premise of the order goes. My order.
Kindly see, it is fishing out the evidence, my lord. Kindly press.
Why fishing out evidence? This is the bone of contention in the suit. Masjid, they say there's a masjid. They seek a declaration regarding that. They say there's a mosque, and you say you deny that there is a mosque at all. And in the survey commissioner's application, they have asked for the details to be relayed and surveyed, and the property to be identified, and to furnish the details thereof. So that investigation is the best evidence.
That is true, my lord. But their
No
prayer,
fishing out.
Your lordship kindly see their prayer. Lordship plain page 18.
Yes.
Page 18.
Yes.
Page 20.
Yes.
আরজি বর্ণিত হেতুবাদে নালিশি সম্পত্তিতে বাদীগণের সত্য সাব্যস্ত মতে এবং বিবাদীগণের কোনরূপ রাইটাল ইন্টারেস্ট না থাকা অবধারণে এবং নালিশি সম্পত্তি তথা উদ্ধার করা ওয়াক্তিয়া মসজিদ থাকা
মসজিদ কমিটির সম্পত্তি থাকা, and entire thing is regarding that the declaration regarding on the premise that it's a mosque, and that has been denied by you. So it has to be seen whether there is a mosque or not. Sorry, I'm reviewing my order and setting aside dismissing the revision. The review in support of the review next para, in support of the application, learned counsel for the review applicant submits that in paragraph number 6 of the said order dated September 24, 2025, passed in CO 342 of 2024, this court had observed that in the absence of any specific challenge to the identity of the suit property, since the defendants / petitioners submit that they have not yet filed any written statement in the suit, there could not have been any occasion for the court to direct such local investigation as prayed for in a suit for declaratory reliefs. Primarily on such premise, the impugned order of the trial court, comma, whereby the application for local investigation was allowed, comma, was set aside on the finding that such investigation was merely for the purpose of fishing out evidence, comma, which is not permissible in law. Whose next parallel counsel points out that in fact, comma, the defendant number one had filed a written statement, comma, which was also annexed to the revisional application itself. Full stop. From paragraph number 6 of the paragraph number from the averments in the said written statement, comma, it is clear that the plaintiff claim that a masjid within bracket mosque is situated on the suit property, and the other description of the property in the plaint was categorically denied by the defendant number one. Full stop. Next para. By way of the local investigation, comma, what was sought to be identified is the suit property and the features thereof. Full stop. Thus, comma, it is submitted that the very premise of the order under review was patently erroneous, comma, since this court had overlooked the dispute raised in the written statement filed by the defendant number one stroke revisionist petitioner. So next parallel, counsel for the opposite party submits that the local investigation was filed for fishing out of evidence. First of learned counsel takes the court to the reliefs claimed in the plaint, comma, which is merely pertaining to a declaration in respect of the suit property being a mosque and ancillary reliefs. First of thus, comma, it is argued that for such declaration, comma, the local investigation sought by the plaintiff was not necessary. First of next para, upon a thorough perusal of the materials before this court, comma, I find that there is an error apparent on the face of the order passed by me on September 24, 2025 in CO number 342 of 2024, inasmuch as the very premise of the order was that the local investigation sought was an endeavor to fish out evidence, comma, in the teeth of there being no dispute to the identity of the suit property. Full stop. Next para, however, comma, such finding is belied by the averments made in the written statement of the defendant number one stroke revisionist petitioner, comma, from which it is evident that the defendant number one has disputed the very nature of the suit property as a mosque while denying the averments made in the plaint. Full stop. Next para. Thus, comma, the local investigation sought by the plaintiff was germane for adjudicating the suit, comma, despite there being no boundary dispute as such, but since the very features and character of the suit property was denied by the defendant number one. Full stop. Next para. Hence, comma, RVW 52 of 2026 is allowed on contest, comma, thereby reviewing and recalling the order dated September 24, 2025, passed in CO number 342 of 2024, along with CAN 1 of 2024, and dismissing the said revisional application, comma, thereby affirming the impugned order bearing order number 22 dated December 5, 2023, passed by the learned civil judge, bracket junior division, bracket closed, comma, second court at Rampurhat, comma, district Birbhum, in title suit number 130 of 2022, whereby the local investigation allowed by the sought by the plaintiff stroke review applicant was allowed. Full stop. Next para. It is expected that the learned trial judge shall endeavor to dispose of the suit as expeditiously as possible. Consequentially, CAN 2 of 2026 is also disposed of, no orders to cause service. প্রথমে একটা affidavit আছে, file to be sorry, I was wrong, entirely wrong. 12টা থেকে তো বলেছি, ডিভিশন বেঞ্চ তো 12টা থেকে বলা আছে। আরে 12টা থেকেই বসবো, এখন চলে যাবো কিনা আবার 12টায়? না, নিচে বাড়ি জালদিয়ার আছে, তাহলে কন্টিনিউ করি। ও সরি, তা তো ঠিক। Division bench people.
No, no, Millard.
Division bench people, but difficulties I have printed that or whichever is earlier, but I forgot that Justice Bhattacharya also has to be there for the division bench. The Justice Supratim Bhattacharya, he has his bench till 12. So I think we'll reassemble into because we kept it at 12 because there at 2 p.m. Justice Bhattacharya has another bench with Justice Arindam Mukherjee. So from 12 to recess we have the division bench. So I'll sit at 12. What can be done? Unless Justice Bhattacharya comes, I cannot sit.
21. I was there, Millard. Millard kept it on 7th, next Friday. Millard, can
Did
it?
I?
Yes, Millard.
I just adjourned it.
Yes, Millard, can it be on 14th, 7th?
Adjourn করেছি তো শুধু।
I'll speak
I've
to.
just adjourned it.
Yes, 7th, I have some difficulty. I'm not there. Can it
No,
be on
then we'll
14th?
definitely take up on that date. If you have some difficulty, you don't want to do it.
I'll speak to Mr. Sanyal, Millard.
You
He has-
speak to him to your heart's content, but I've just adjourned it for the day. If I sit on that date, I'll take up the matter and grant no adjournment on your behalf.
14th.
No, no. I've just adjourned. Whenever you sit next, if there is no matter, no other matter on that date, we will not sit.
No, Mr.
Not now, not now, no.
14th, Millard.
No.
I'm sorry. Minus with the leave of my lord Mr. Justice Supratim Bhattacharya, may I mention item number 1 of the ordinal side list, single bench.
Yes.
There's some miscommunication between the client and the learned advocate on record. He doesn't want to withdraw simpliciter.
No, we gave you leave to.
No, he doesn't want to withdraw simpliciter. He, with some observations, he is seeking basically remand. So, my lord, if your lordship has not signed the order, subject to your lordship, if you
No, it was passed in open court, Mr. Majumdar.
other side is present, my lord.
No. Order passed in open
Then we
court.
will
That's
take
one
out a formal application and come back.
one-page application
Yes,
and
yes,
do
we'll
that.
come. Really.
Please do that. One
Yes,
page.
I'm so sorry, my lord. Kindly,
No,
my lord,
no
it's
difficulty
on
there. Just put in a one-page application.
Yes, yes, we
Have
will
it
do that.
mentioned with
Well, I
leave of Justice
understand that.
Bhattacharya. I will put it on the
It has
next.
been pronounced in open court. Yes, yes.
Your Lordship, may I mention one matter with your Lordship permission?
Yes, ma'am.
Item number 12, I'm seeking for not today, your Lordship. Mr. Rachit has gone to Delhi for some case.
Ma'am, difficulties when we our system is when we call the matter, then we'll unless your others. So let it be called on at that point.
Yes,
of time,
your Lordship.
We will consider.
Yes, your Lordship. I'm deeply obliged.
Yes. What do you want now?
Calling for the lower court record.
Yes. Can what do you want regarding that? Can to be listed?
Yes, it has not yet been.
Yes, we have. Yes, mention it.
Lordship, may I permission one correction order, my lord?
Yes.
Code number 13. Order passed.
This combination.
No. Code number 13.
What code number 13?
Rajshakhar Manta sitting with.
Can we correct their order?
It is their order.
How can we correct their order?
Only district Malda, it will be district
No.
Dokhin Dinajpur.
Mention before that. What is the matter? Under what heading? Under what heading, ma'am? It's an application or hearing? What is a can?
Can 8.
No. Call.
For the appellant, my lord.
Yes.
My lord, this
Yes, sir.
is can number 1 of 26, which is a stay application I filed against
The appeal is against what?
against a preliminary decree passed in a partition suit. My lord,
So where you are passing the usual order, the final degree proceedings will continue, but no final degree will be drawn up. You serve copy on the other side and come back. The present appeal has been preferred against the preliminary degree of partition. Full stop. The learned trial judge shall be at liberty to continue with the final degree proceedings. Semicolon. However, comma, no final degree shall be drawn up without the prior leave of this court, comma, till disposal of can 1 of 2026. The stop. Next para. The appellant stroke petitioner shall serve a copy of can 1 of 2026 on the respondent, indicating that the application shall next be listed in the monthly list of September 2026, when an affidavit of service to that effect shall be filed by the petitioner. Next.
Madam, for the appellant.
Yes,
So
Mr.
this is
Ghosh.
application for stay, appeal out of arising out of a money decree.
What is the decretal amount?
16 lakhs. 87,350. I may submit one thing.
Yes.
I know lots of the procedure that you have to deposit it, but the thing is that my property has been attached before judgment. If you also kindly see the order once. Kindly come to page 38. Sorry, madam, page 29. Page 20. I'm extremely sorry. Page 20. But one application has been filed under order 41 rule 5 that was allowed by the learned trial court, and my house has been attached before judgment.
But that order goes with the final degree.
But since my house has already been attached, if you also kindly consider, because this relates to this is a peculiar fact of the case. Petitioner was an employee of Food Corporation of
Don't
India.
know the valuation of that property, I mean, whether it would suffice.
It's a residential house at Uttarpara.
What is the claim on account of?
My lord, what type of submitted? Petitioner was an applicant was an employee of the Food Corporation of India.
Excess salary. You took withdrew excess salary.
Would the excess salary, whether that is permissible or not, firstly, and secondly, whether the limitation will come or not. These two issues are
For the time being, ওই attachment টাকে এটা continue করতে বলে ইয়ে করে দিচ্ছি. For the time being, we will direct that attachment to continue. And
that
subject to
will
that, but this will be till disposal of this application.
Yes.
We'll hear them and keep it
Yes,
open
sir.
for being decided.
Yes. So his retired employee, he may not be able to pay
Retired employee.
Retired employee. After retirement, everything has been happened.
The present appeal has been preferred against a money decree on the ground that the appellant allegedly withdrew excess salary to the tune of rupees 16,87,350 oblique dash. Which of next para, learned counsel for the appellant submits that the appellant is a retired employee and all the steps implicating the appellant were taken after his superannuation. Which of next para, learned counsel submits that since the residential property of the appellant was already attached before judgment under Order 38, Rule 5 of the Code of Civil Procedure during pendency of the suit, the same provides sufficient security for the money decree, and as such, no further direction may be given for grant of stay, as a condition for such stay, for the appellant to deposit the decretal amount. Which of next para? Upon hearing learned counsel, we are prima facie satisfied that the residential property of the appellant, which stood attached before judgment by dint of order number 6 dated September 4, 2019, passed in money suit number 6 of 2019, furnishes sufficient security for the time being for the decretal amount. Which of next para, since Order 41 Rule 5 of the Code gives a leeway to the court to decide the appropriate security as a condition for grant of stay, we construe such attached property to be sufficient security for the time being, of course, subject to being adjudicated finally, subject to such question being adjudicated finally at the final hearing of the application. Accordingly, the operation of the impugned judgment and decree dated April 28, 2026, passed by the learned civil judge, senior division at Shuri, district Birbhum in money suit number 6 of 2019, and or any execution case, if levied in respect thereof, shall remain stayed till disposal of Can 1 of 2026, subject to the condition that the residential property of the appellant, attached vide Order number 6 dated September 4, 2019 in money suit, passed in money suit number 6 of 2019 by the learned civil judge, senior division at Siuri, district Birbhum, shall continue to be under such attachment, coextensive with the ad interim order granted by us today. Which of next para, the appellant shall serve a copy of Can 1 of 2026 on the respondent, indicating that the application shall be listed in the monthly list of September 2026, when an affidavit of service to that effect shall be filed by the appellant. The appellant shall put in postal costs and requisites for service of notice of the appeal on the respondent within a week from date. Next para, the trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited within a week. So next para, the appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant.
Much.
Yes.
Item number 3, I've been instructed by the learned advocate who is suffering viral fever to seek an adjournment for today on behalf of the appellant.
An accommodation is sought on behalf on the ground of the ailment of learned counsel for the appellant. Accordingly, let the matter stand adjourned till August 3, 2026.
Grateful, Your
Please give your name, sir.
Yes.
Item number 4, please.
My lord, I am being led by Mr. Shuddha Satta Banerjee and Mr. Bachawat, but I'll trouble your lordship till Mr. Banerjee is here.
Yes.
So items 4 to 6, my lord, are connected matters. 4 and 6 are appeals instituted earlier against an ad interim order, my lord, and 5 is my appeal, the new appeal against the order being
Let us
made
take up
absolute.
the order appeal passed against the filed against the parent order first. Because that order is the genesis.
That order is the genesis.
You
There,
satisfy us on that, then you'll hear the other side on
yes,
the other.
in that those appeals, my lord, against the parent order, I have already got the leave to appeal. My lord has given me the leave to appeal, so I am moving.
Why
the
leave to appeal? You are not a party.
I am not a party to that
Oh,
suit,
that.
my lord. Yes, that matter, my lord.
Yes.
So item 5, my lord, is the new appeal. I'll be moving the leave to appeal today for item 5.
Leave was granted on what ground in the other appeal?
In the other appeals, my lord, leave was granted because I had been able to show your lordships that I had a pre-existing pledge and charge on mortgage properties. Later in the suit, my learned senior friend's client filed the suit before the city civil court. So there they showed a letter of comfort, which had also been given by the borrower to them, basis which the same shares.
These are Kitply shares.
These are the Kitply shares held by a company called Platinum. So Platinum had pledged its shares to me, and those shares have now been basically injuncted from transfer.
Leave was granted in respect of
items 4 and 6, my lord.
So this is against another extension order.
This is the interim order being made absolute.
Let me come. Yes.
This item 5 is the appeal against that interim order now being made absolute.
No, this FMT 231 of 2026, which is item 6.
Yes.
Sorry, item 5 is the appeal against the final order.
Is against the final
For all
order.
practical purposes, that becomes the main appeal.
That becomes the main appeal.
On similar logic, why shouldn't you grant?
No, Your Lordship. Now I'll tell you. On the last occasion, what there is no similar logic anymore, because something they have annexed. Because I was not privy to what was happening. What they have annexed now in their Can 3, that is become the crux of the entire matter now. That is an order of the Guwahati NCLT. And I am also privy to the fact that in the last occasion, my learned friend had said that this is between the same parties on the same thing and all that. It works as kind of a res judicata. Long back, 300 years back, the law was set down that the court cannot be said that it was mistaken in another corresponding proceeding, but it can always say that it was misled. And so were we. We had no clue.
At the leave stage, you don't have a right of.
No, Your Lordship.
That is what has been observed by my lord.
May I indicate one thing?
But you can indicate court can hear. Court has the right to hear.
Absolutely.
Court always has the power.
The fulcrum of their case is that they have a debt, and the debt is with regard to a pledge of shares. A pledge of shares, same shares. Whether they have a debt per se, that money is receivable or not, that is not the crux. It is on the pledge. The Guwahati NCLT, what it has done is, I'm not relying on the order per se, but on the
ratio.
No. On what has been held to be facts and take and the.
They were parties there.
They are the parties. Can you just?
I am the party there. I had filed the section 7 against Kitply. My learned friend is not a party.
Yeah, obviously that's why I didn't know. Your Lordship's earlier order was passed sometime in May. This order has come subsequent to that. We were not privy to this order also, but it is when they filed and they have annexed it in their Can 3. Can 2. Sorry, there is no
leave. Can 1 is the leave, Can 2 is the stay application. There is no
yeah.
Can 3 here. Can 3 is in the other appeals.
Other one, yes. Because now Can 2, that is when we come to know of this. And paragraphs 39, 40, 41.
Is the fact which changes the circumstance?
I'll tell you. What they note down is that they themselves, and that is the fact on basis of which they also didn't pass an order, that they themselves in the Kolkata NCLT, when the CIRP proceedings against this company was going on, against the petitioner here, they have said these transactions, which include this entire pledging of shares and all, are fraudulent. These are fraudulent transactions. These are on round tripping.
Which they are pledged.
They have said the pledge, yes, includes.
Pledge on which they are relying.
Yes. Now they are relying on the pledge. I am not.
That is decided by a forum.
No. It is, Your Lordship, they themselves have.
Saying issue estoppel sort of. I mean, they have taken a different stand there.
Yes, absolutely. And that is the basis of which the NCLT has also decided. NCLT there have said there is no financial debt. If you have any monetary claim, go before your arbitration, which is going on, nothing before the NCLT. On the same relation of same documents. And it is they who themselves have said, and that is what is narrated in that order.
So you say that if they say that the pledge is vitiated inter alia by fraud, then they cannot rely on the same.
They cannot, because at their case is not that they have a monetary claim against Kitply on the basis of which they want to be added as parties. They are saying on the shares. They are relying on that. And your lordship, it will be also very evident.
My
scan 2 in which
this is scan 2 in item number 5, lordship.
Five. এটা আপাতত সরিয়ে রাখুন।
My lord, if I may, we are on the leave to appeal right now, which does not proceed. It's not that I have not disclosed this NCLT order that my learned friend is referring to. That is in my stay application.
No, but what is your
Your lordship, before that also, before even going into that, okay, I just wanted to show how this entire thing is being going on. Please come to page 23 of Can 1 itself, where they have disclosed that pledge. Because all these documents, if your lordship remembers, last time when they had filed a bare 5-page document, and I had taken the point, no particulars have been given, and then showed judgments. Your lordship had said, no, there's a hint, so I'm going to allow at this stage, and we'll see.
At this stage, it's prior facie.
Right. So now, thankfully, now they have added these documents. This time round, to safeguard against that, they have added these documents. Now it becomes clear, because I didn't know what pledge they are talking about. If your lordship just comes to page 23 onwards.
Yes.
Sorry, from 21, there are these signatures. If your lordship sees, this is the 23 unattested indenture of pledge. That's what they have shown. I'll come to the stamp point later on, but that's not. I just wanted to show what's the entire thing they are going on doing. Your lordship will come to first. Page, please comes to page 53.
Yes.
Your lordship, please, it's all blank.
One signature is there.
One signature, but when it has been executed, what date, the nature later, everything is blank, and it is notarized also.
Saying that this is not.
And your lordship then comes to page 54,
yes,
which are the particulars of the shares, and your lordship sees the column is blank. This is what they are relying upon.
In the body of this indenture of pledge, the shares are mentioned somewhere. Must be mentioned.
Maybe mentioned, your lordship.
Yes,
Maybe
they are mentioned.
But your lordship, this is on the basis of pledge. The factum of pledge will come from this document, not what is written in the indenture of pledge. This is the factum, because this is what they have to place, on basis of which they will have the pledge. They are going to enforce their pledge, which is blank. And then, your lordship, now we come to the more important part, that if your lordship has a look at it, though it is not my place, nothing to do with me, but this document requires to be impounded. There's only 300 rupees stamp duty which has been paid, non-judicial stamp. On the face of it, if your lordship is looking at prima facie, your lordship, on the prima facie, this document is most of it is blank. The main particulars are blank. Then it is insufficiently stamped, clearly insufficiently stamped, and that's completely it's not even prima facie, your lordship. It is ex facie.
Relied on the
now
order, and he's showing this. This is blank, page 53. But format of pledge letter is
now your lordship will come to.
It's not properly stamped.
Can 2, that document which.
My lord will kindly allow Mr. Bennett.
Yes, we will allow.
Yes. Your lordship will come to page 234. Can 2.
And 2 is the lead.
It is they have themselves annexed. I had no
13.
234.
234. Yes. Yes. 234.
Just give me a moment.
You also come to page 234.
Yeah, I'll just come to this one. Your lordship
You have to be on the same page for you to get an order.
Your lordship will come to page 286 in that.
286.
286.
So we'll keep both together, open together.
No, 286.
No, both will be required.
No.
No,
286 is the running page of the judgment, this order itself.
This is that their submission before the NCLT.
Yes. No, they had not the NCLT. NCLT has noted the submissions made by them before the Calcutta NCLT in another.
How did the NCLT note that? The other side pointed out. There are.
It must have been, Your Lordship. Again,
Yes.
Your Lordship will see from paragraph 32 onwards.
That is not at page 286.
25, sir. 25. 25.
Yes.
It talks about this particular debt which we are talking about, paragraph 32. This is the entire same transaction which is going on.
Yes.
And the pledge agreement is mentioned in paragraph 33.
Look, I'm just sorry. I just need to understand. Mr. Sinha is appearing for the plaintiff, with whom I have no privity. Who are you appearing for?
That is correct.
Plaintiff.
Yes.
That is sufficient indication.
That's it.
Yes, Mr. Sinha.
The Lordship will look at the pledge agreement by shareholder dated so and so.
Yes, yes.
Now your Lordship will come. Paragraph 36 onwards. The financial creditor further submitted that the liabilities arose after approval of the earlier resolution plan, so and so, and therefore constitute fresh and independent transactions unconnected with the earlier CIRP.
No, did you show it to them?
But do they say it's fraudulent?
Yes, I guess.
Come to the best portion first. You can't wait to.
Your Lordship will then come to page 293. I would have been speaking to you, but
Yes.
paragraph 61. After going through the averments and documents, the tribunal is now indicated. This tribunal finds that the very foundation of the present proceedings under section 7 of the code becomes doubtful, as the present petition itself arises out of the same alleged debt under contract number so and so, dated 24/1/2019. This is the same transaction. The financial creditor in the present section 7 proceeding has claimed and
Administrator has stated that those are fraudulent.
Yes.
Administrator has taken a stand that those are fraudulent.
Administrator is them. Administrator
under
is them.
administration,
Yes,
yes.
it is them.
Yes.
If the administrator is saying that in another proceeding that these are round tripping and fun, Your Lordship, it is between them. I cannot be prejudiced because of this. These are fraudulent proceedings, and I am not even on this part. What I am on, Your Lordship, whether it is fraudulent, whether it is not or not.
No, you're on their stand. You cannot take double standards. That
At
is your
that
point.
time, no, Your Lordship, my case is slightly higher. At that time,
Yes.
when they came before Your Lordship for the first time, that order, this stand had already been taken in the Kolkata NCLT.
This fact was suppressed by them.
Yes. And I will show judgments, Your Lordship, after whatever my learned friend, if
Not at this stage.
the judgments, no, because I have to get into the fact, Your Lordship, that the judgment says any kind of misrepresentation or suppression. After that, even the question of res judicata can be opened up. If there is a balance is that it is a res judicata point, even that can be opened up. There is a Supreme Court judgments on that point also, Your Lordship.
So something vitiated by res judicata, vitiated by misrepresentation
Fraud
cannot
can-
operate as a res judicata.
Yes, absolutely. It's a general principle, but I just, Your Lordship, this is my case. But today, I was not aware of all these transactions and all at that stage. When we had earlier decided the earlier two applications on right to appeal. Today, these documents have come into light, and I'm showing it clearly that the administrator, they themselves have said in one proceeding.
Let us
And-
change the manager on this. Yes.
Your Lordship, we can give an affidavit if required.
No,
We
not
can-
at this stage. Not at the leave stage.
Just quickly.
But we are taking note of his submissions,
Yes,
Mr. Banerjee, and you will have to satisfy us on that also. Otherwise, that these pledges are there. 3 points. We are just
Yes.
indicating to you.
Just on those 3 points, I'll
NCLT, you, the administrator means you.
no,
and-
administrator, firstly, it's not.
that will distinguish. Secondly, blank pledges.
Yes,
Page
that
54,
also I'll quickly deal
and
with that.
insufficiently stamped.
But first, I'm sorry, Milord, and
Insufficiently stamped.
Yes. See, let's come to the first issue first. Page 49. That's what he started with, I'm told.
Page 54.
He had showed,
54.
page 54 he had showed.
Page 54 of can 1.
Yeah, 54 of can 1. Yes, Manoj.
Page 54 of can 1 and page 86 of 293 of this can 2 primarily.
Letter for pledge.
Page 53 also.
Page 54, your lordship will see.
53 also. 53 he says, Mr. Sinha says that this is not signed. I mean, only one signature is there, but there are blanks basically.
All this will be answered with just page 49. Particulars, those are all additional pledges. How this thing is now being got up, it's very, very clear. Platinum is the 100% shareholder of Kitply. The loan of about 120 crores is taken by Kitply. Kitply pledges these shares at page 49, which your lordship finds, in my favor. A section 9 is invoked. All this has happened in 2019. On the basis of a letter of comfort apparently executed for a loan of 2.5 crores, the entire shareholding is pledged by Kitply in favor of this plaintiff. This plaintiff is now questioning my round tripping, which is why I put that question to him. And arbitration is separately going on between me, Kitply, but Kitply has never questioned the disbursement. Kitply's defense there is that this is a round trip. How is it round tripping? Money has gone in through various other companies.
Kitply, it is Kitply which pledged these shares with you.
Yes.
Platinum for
Platinum for the share. Because that's page 49.
Yes.
And this plaintiff who
Kitply pledged the platinum shares with you.
With me.
No, Platinum.
Platinum is the shareholder.
Yes.
The other way around.
It's the other way around.
Reversing. Yes.
It's the other way around. This apparently
shares are of Kitply.
That's right. Shares are of Kitply. Now this plaintiff
and Platinum is what is the Platinum is a party here.
100% shareholder of Kitply and is the defendant
Platinum
number.
Is a defendant here.
Defendant. And apparent, so whatever, that's in the arbitration. That's in the arbitration. What today I am at a stage of leave to appeal.
No, even especially on whatever your documents are, Mr. Banerjee, we are going by only the documents you have annexed in your application.
Yes.
One is that now this.
My case is very, very simple before you
deal with this. Page 54 does not give any clear. This is the letter of pledge.
That's the additional. Page
Apart
49
from
is
shares.
Apart from these.
There are no additional shares.
There are no additional shares.
What about lack of signatures in at page 56?
In the arbitration. So that is my point. That is today.
Just wanting efficient satisfaction, Mr. Banerjee. What about this insufficiency of stamp and lack of particulars here?
No,
so you discussed to give a go by to 54 for the time being because those are in respect of additional shares.
Yes, page 50 also.
Yes.
Which is part of page 53. That is an irrevocable power of attorney.
But
the fact that
is kept blank and all.
I'll if your lordship desires, the fact that Kitply has pledged these shares to me is not in doubt.
But you take a stand before the Guwahati NCLT. That
I don't.
Your
My administrator does. Now I am out of administration. The administrator
bound by that.
No, that is just at an application stage.
Whatever.
That's just at an application stage.
Administrator is you.
Now NARCL has taken over.
Changed. The entity has not changed.
NARCL has taken over.
Whoever.
The administrators filed an application under 66.
But there they took a stand.
The issue that will probably come up here, and I'll address these.
You are not pressing that application.
No, that I don't know what is happening
Even
there.
if you either press or not, Mr. Banerjee, it's you, the entity. You are the new managers, the new owners.
The question that probably will come up is this particular injunction that he's got. He's gotten on the basis of a letter of comfort of
we are only
shares of pledge. Only on the leave.
So if you take a stand, your
only on the leave.
Administrator had the authority to represent you at that point of time. Therefore, it has to be constituted to be this company's stand, Shrey's stand. You are a new management. Management is not a
There
different
is no,
entity.
firstly,
Stray remains stray.
Firstly, I'm standing at a stage today where the 66 is just an application that has been filed. Separately, the party who has filed the leave to appeal before your lordship today has filed an application for invocation of this pledge and for recovery of this money that's given to Kitply. The validity of this charge is before another judicial forum. This charge is admittedly after my charge. Kitply has never disputed the fact that Kitply has given these shares to me. That now the only question is that with my prior charge being an issue before the arbitration, whether a later charge holder can have an injunction which can impinge upon my right.
What is the issue before the arbitrator?
I have read shares and the money that I've lent to Kitply. And the 66 proceeding is by the administrator is for a different purpose, the recovery of money.
Can you take contradictory stands
Well,
in different forums?
Two things. One is that is at an application stage. Here, I've moved to section 9. I have an injunction against Kitply. I have a prior charge. A latter charge holder has come and gotten an injunction
You are enjoying a section 9 order.
I am enjoying a section 9 order, which has now been sent to section 17. That has also been confirmed. Now, section 17 final hearing is pending. That and this is also all these points are taken there by Kitply. Today, whether the plaintiff wants, and I'm actually not even on the merit. If I may just frame it as a question, once a plaintiff has obtained an injunction in respect of shares that I claim to be pledged in my favor, whether I have a right to say that I'm affected by that injunction or not. It's just that we are at a stage where I'm seeking leave to appeal, where the plaintiff has obtained an injunction in respect of shares that I claim are pledged to me, whether I can say to be affected by that injunction or not, and I don't need to step any further. Well, I am not showing this as a precedential value anymore. I'm showing this as an issue which stands foreclosed in law between these parties. And for the sake of completeness, I'll refer to the judgment.
Platinum is the defendant in this suit.
Yes, Kitply, Platinum.
So the injunction has been obtained against Platinum.
Platinum and Kitply,
which in turn has placed the shares with you.
That's right. And now I can't take any steps. So in the event I succeed, if this so what is it that I need?
In the event you fail in your plea before the Guwahati NCLT
and that
has failed.
Very well.
There has not been not been decided that it's fraudulent document. Their plea has not been accepted.
He's excited about the other one.
No, we are excited about his excitement. Contagious actually. We are getting very excited.
And one more, the administrative bit.
No, Mr. Siraj, do you say that application of theirs where they alleged that it was a fraudulent, those pledges are fraudulent, that has been turned down?
No. That application is going on.
So
what has happened here is they.
What happened to Guwahati? What happened to their application?
Guwahati, they filed a
My
section 7 application.
My 7 that I filed.
They wanted to enforce
because
the pledge.
This plaintiff gets very excited by this.
Yes.
Plaintiff doesn't get excited. His counsel.
Counsel gets excited.
The counsel.
The 7 that I had filed, that 7 got rejected on the ground that because the question of the transaction itself is pending, there can't be a straightaway classification of this transaction as a debt.
Because it's a summary jurisdiction.
Because it's a summary jurisdiction.
So therefore, either way, your allegation that it's a fraudulent transaction has not been decided.
It has not been decided. So in the event 66 goes, and even if that goes, my arbitration is pending. And in the event my pledge and the recovery of money is allowed.
Arbitration is initiated by
me. By NARC, straight
to enforce those pledges,
to seek the recovery of the money and for enforcement of whatever securities that Kitply has given to me. Now and that's a prior charge. A latter charge holder. Now, may I just sum this entire issue up by relying on one decision? And I'm calling this a decision and a judgment. Please have a look at.
On what point? 7.
The division bench that allows my leave to appeal in this matter.
No, Mr. Sinha says that that's vitiated.
I'm with deepest of
tainted
with a lot of humility towards him. And
did not tell us that this before the Calcutta tribunal that challenge was there. That stand was taken by the administrator. That is what he says. Guwahati records Calcutta stand taken by
Yes, yes.
administrator.
Matlab, my 7 gets rejected in Guwahati because it's a summary jurisdiction and because it is
What
a,
happened to the Calcutta? I mean, Calcutta.
it is pending. The 66 is
In Calcutta,
pending.
you still take the stand that it's
I
a
don't.
fraudulent.
But most importantly, in the 66 application, the issue of disbursement is not in doubt.
No, the
So
pledges, the
pledges
veracity
is
of
not in doubt. That is also not in doubt.
administrator has taken a
No,
part towards it,
administrator had taken the plea of round tripping because apparently it has gone from party X to party Y and come back to party X.
Yes.
Now, if this fraudulent transaction the administrator can't prove, he doesn't dispute that the fact that the money has gone from party A. In fact, in the Kitply in the arbitration also does not come and say that the money they have not received or that they have not pledged these shares.
asked for the money to be returned.
And
The 66.
part of the
The
66
present injunction has been passed in a money suit filed
in
by
a money suit.
where they seek to enforce that security.
That's right.
Their own.
There, 120 odd crore loan that I have
prior charge over there.
I have a prior charge.
Obviously.
The dates are all there, and just the optics. 120 crores I have lent. Disbursement admitted in every forum.
That leave was granted to you in respect of the same suit or different.
This suit, which ad interim injunction I came up,
Good.
that has now attained finality. That leave to appeal is I'm seeking now.
Your Lordship, may I just two paragraphs?
May I now one thing before I understand his, with some humility, this plaintiff really does not have a right of audience now.
Recorded in his last
And that is your Lordship's last order.
Yes, yes.
He really cannot come and question that. One is right of audience. Second is because I don't have a privity with him. He cannot question the transaction that I have, which the others are not questioning. He asserts to be a charge holder in respect of something which was prior charge. He has not assailed this charge in my favor.
Yes, Mr. Sinha, quick.
Only. Your Lordship will come to, I will show 3 paragraphs.
No.
Your Lordship will
This
come
will
to
never end, Milord.
287. No, your Lordship will just listen. Please come to 287. Page
What do you want to say? Tell us.
I'm just noting down what has been said. The administrator of the financial creditor, that's them, itself sought declaration that the transactions amounted to fraudulent and wrongful trading under section 66.
Wrong.
1 minute.
Oh, he sought for the money back in that also.
No, please, your Lordship, there is 66 is not about money back.
So he is not there in that proceeding.
May I?
He
There
can't
is
have
section
rejoined.
No. Section 66. Your Lordship, at the end of the day, they are saying that this is a completely fraudulent transaction. Please come. Then this is 43 in page 287. And then page then 288. Paragraph 45. After noting down, says thus the very financial creditor through its administrator. Your Lordship, page
Yes, seen it.
has itself questioned the genuineness and legality of the underlying transaction in independent proceedings before another coordinate bench. And so they are challenging this entire pledge, this transaction itself. This is what I was indicating, Your Lordship.
Yes.
The tribunal is
No, Mr. Sinha, we have heard.
serious
We have heard.
inconsistency. And Your Lordship, the paragraph 62, it says
Yes, they have challenged it, we have seen.
the financial creditor cannot be permitted to approbate and reprobate.
Can 1 of 2026 has been filed for leave to prefer the appeal. So at this stage, the plaintiff, you are for respondent number?
One. Your Lordship,
One.
I'm for 1.
The respondent number 1, who was the plaintiff in the trial court in the suit from which the present appeal arises, contends that leave ought not to be granted. Next para, it is submitted by learned counsel appearing for the respondent number 1 that although similar leave was granted in respect of a different appeal arising at the ad interim stage, the same does not operate on the principle of res judicata in view of the order granting such leave being vitiated by suppression of material facts and misrepresentation on the part of the present appellant. For some next para, learned counsel points out that in a proceeding before the National Company Law Tribunal, Guwahati bench, the self-same appellant, comma, through its administrator, who was then in charge of the appellant company, comma, had taken a stand that the very pledges which formed the plinth of the present leave application were tainted by fraud, comma, round tripping and wrongful trading transactions. Whose of next para, by relying on the relevant paragraphs of the judgment of the Guwahati bench of the NCLT, comma, which is annexed to the stay application, the interim application of the present appellant, comma, learned counsel for the plaintiff stroke respondent number 1 submits that in view of the veracity and legality of the very pledges having been challenged by the appellant before the Kolkata NCLT, comma, which was duly recorded by the Guwahati NCLT, comma, the appellant cannot do a volte-face and take a diametrically contrary stand to impede themselves to get a leave to prefer the present appeal. Full stop. Next para. Secondly, comma, learned counsel for the respondent number 1 submits that the pledge on which the letter of pledge on which the appellant seeks to rely on does not enumerate the particulars of the shares of Kitply, comma, which are also the subject matter of the which are supposed to be the subject matter of the pledge. So the next para, learned counsel additionally points out that the document allegedly evidencing such pledge, comma, which is an unattested indenture of pledge, comma, is an unstamped document, insufficiently stamped document, comma, due to which the same cannot be looked into by the court even at this stage. So next parallel counsel appearing for the petitioner submits that although a stand was taken to the effect as contended by the respondent 1 by the then administrator of the appellant company, comma, such stand has not been vindicated as yet by any order of any competent judicial or quasi-judicial forum. Secondly, comma, learned counsel argues that on the strength of the said pledges, comma, the appellant had obtained an order, an interim protection under Section 9 of the Arbitration and Conciliation Act 1996, comma, which was reiterated at the ad interim stage under Section 17 before the arbitral tribunal when the matter was ultimately referred to arbitration. Full stop. You are for the
before I am the respondent in that.
learned counsel for the respondent in the for Kitply, comma, which is also you are also a respondent here. Also a respondent in the present appeal, comma, points out that an application for vacating such ad interim order is pending before the arbitral tribunal, and the Section 17 application is still pending. Full stop. Next para. Learned counsel for the petitioner continues to submit that the letter, within double inverted letter of pledge, comma, which does not purportedly contain the particulars of the shares, is only in respect of additional shares and not the shares pertaining to the present dispute. Full stop. Next para. Moreover, comma, it is argued that the question of the document being insufficiently stamped can only be looked into at later stages. Full next para, learned counsel submits that the plaintiff stroke respondent number 1 does not have any locus standi to even contest the leave application, comma, since the said application is between the court and the appellant. Full stop. Learned counsel relies on the findings in that regard in the earlier order granting leave in respect of a previous appeal from an ad interim order passed in the self-same suit. So, next para, after considering the arguments of the parties, comma, we are of the opinion that the appellant is justified in contending that at the stage of grant of lease, comma, leave, comma, the matter is between the court and the appellant seeking leave, and the respondents do not have a right of hearing at that stage, comma, particularly in view of the respondents not having any right even at the subsequent stage, comma, if such leave is granted, comma, at the time of hearing under Order 41 Rule 11 of the Code of Civil Procedure. To sub next para, however, comma, we are of the further opinion that such absence of right of the respondents does not automatically translate to a fetter on the court's power to hear the respondents if the court so feels necessary, comma, if not as a if not on an adversarial mode, comma, at least to get a proper picture of the facts attending the leave application. Full stop. Thus, comma, we take note of the arguments made by the respondent number 1 and respondent number 2 is kit play. Right. Respondent number 2 kit play. Full stop. Next para. However, comma, even upon such consideration, we do not find any impediment in granting the leave as sought for the following reasons. Full stop. Next para. Insofar as the apparently contrary stand taken by the appellant before the Kolkata NCLT, comma, which was recorded by the Guwahati NCLT, comma, to the effect that the pledge of the shares, which is the premise of the leave application, is vitiated by round tripping, comma, fraudulent transactions, comma, etc., comma, has not yet been adjudicated finally before any judicial or quasi-judicial forum and is now sub judice before the Kolkata NCLT. Full stop. Next para. Thus, comma, it cannot be conclusively said at this point of time whether those pledges, whether such pledge is vitiated or not. Full stop. Hypothetically, comma, if ultimately it is, if the matter where the challenge is pending is is decided against the appellant, comma, holding that the pledge is valid, comma, not being vitiated by round tripping, comma, fraud, comma, etc., comma, in such event, comma, the appellant's right to have a claim on the pledge does not automatically evaporate. Full stop. Next para. By merely preferring a challenge before a judicial / quasi-judicial forum, comma, it cannot be conclusively said as to the pledge being invalid in law or on fact. Full stop. Next para. Thus, comma, at the stage of grant of leave, comma, this court does not intend to go into the merits of such challenge leveled by the appellant before a different forum. Full stop. Fact remains that on the basis of the self-same pledge, comma, the appellant has succeeded prima facie to obtain a protective order under Section 9 of the 1996 Act and thereafter to have an ad interim order to the same effect under Section 17 of the said Act before the arbitral tribunal. Full stop. The mere pendency of a vacating application or the Section 17 application does not automatically denude the ad interim protections granted by the Section 9 court and the arbitral tribunal on the strength of such pledge in favor of the appellant. Full stop. Next para. Thus, comma, at present, the issue of whether the pledge is valid or not is in a state of flux and cannot be conclusively construed to be a bar in the appellant relying on the same for the purpose of obtaining leave to prefer the appeal. Full stop. Next para. As far as the insufficiency of the stamp is concerned, comma, the same can only be decided at a later stage, comma, as and when the document is relied on for the purpose of adjudication on merits by any court. Full stop. Next para. Insofar as the lack of any particulars of the share is concerned, comma, we prima facie find substance in the contention of the appellant that the documents letter of pledge referred to pertains to additional pledge and may not, of which the pledge of kit ply, which is under contention here, may not be the subject matter. Full stop. Next para. Even otherwise, comma, for the purpose of grant of leave, comma, the court is to see whether any substantive prima facie right of the appellant, comma, who is seeking the leave, comma, is affected by the impugned order. Full stop. Next para. proceeding from such standpoint, it transpires that irrespective of the challenge by the appellant to the veracity of the legality stroke veracity of the pledge before different forums, fact remains that the appellant has a money claim on the strength of such pledge against Kitply. The pledge is only a security thereof, but nonetheless, forms a bulwark of the impugned order. Bulwark of the said money claim. Next para, by the impugned order, it is the self-same shares, which are purportedly pledged with the appellant, which have been injuncted from being transacted. Next para, thus, for the limited purpose of considering whether any right of the appellant has been prima facie contravened stroke violated, we find that sufficient case has been made out for the purpose of grant of leave, as the impugned order of injunction in respect of the self-same shares which are allegedly pledged by Kitply itself, pledged by the the Platinum is the defendant. By Platinum, the defendant stroke respondent number 3 in the suit from which the present appeal arises, the appellant has sufficiently made out a case for grant of leave. Accordingly, can 1 of 2026 is allowed, thereby granting leave to the appellant to prefer the instant appeal. Yes. Now the appeal.
Has observed that the question of admissibility on the ground of stamp test is not decided by a court. If it can be said court and not by any other forum.
No, your lordship is saying it. There is a law. Yes, you are right. যেখানে insufficiency of stamp একটা কথা বলেছি যে can only be at the stage of adjudication, court কে refer করেছি, and or any judicial stroke quasi judicial forum. Yes. The order pattern will take up on some other day.
Yes.
We have to hear others, some matters. Because my learned brother has a bench.
I just think in the can 2 or the 41, he'll seek affidavit.
That is an order for 27 application.
No. It just I have asked for a injunction.
Say application.
So we admit the appeal then and,
Yes, and
direct affidavits on that.
Yes.
Injunction has been granted. Against that you have challenged.
Against that I have challenged.
So we will not pass any ad interim stay at this stage. So definitely we'll admit the appeal and direct.
But I was only praying for this as an order. The appeal can be disposed of. That I don't want to have his injunction removed. That this injunction will not be a bar from enforcing my pledge. Or it that's all.
Much ado about nothing.
My injunction.
Then I don't need
how my injunction goes. Your lordship, I will file my affidavit. Say your lordship.
No, but this.
No, Mr. Banerjee.
Then let us just come back another day. Let's just come back another day.
In these situations like this, generally what I could understand and gather, the person is complaining can by security challenge it, he's generally made a party to that suit so that his security is protected. Because it's a security. Until there is a decree and execution, but unfortunately, the application for admission
got rejected.
Challenged.
Rejected by the trial court?
Yes. On the ground that I can't have a counter claim.
That has not been challenged by you?
No, that's not been challenged.
Write down a challenge, Mr. Dutt will settle. he's just and he can't help himself.
We would have loved to do that, but he's gone for the other side.
Yes. So very well, the matter shall be listed on August 3, 2026 under the very well, we are admitting the appeal. The present appeal has been preferred against a temporary an order of temporary injunction. At this stage, the grant of any stay, ad interim stay, would tantamount to allowing the appeal before finally hearing it. Next para. Accordingly, we direct the respondents to file affidavits in opposition to can 2 of 2026 within 3 weeks. Within 3 weeks from date. Reply finish shall be filed within 1 week thereafter. The application shall be listed in the monthly list of September 2026. It is made clear that in the event both parties so agree, At that juncture, comma, the appeal along with the application may be taken up together for hearing. If you agree, because ultimately whatever happens in this. Thank you.
Much obliged.
আগামীকাল আসার কথা ছিল না সেটা আরেক সবই ভাই সব এরাই সব ঘুরিয়ে ফিরে আসবে হ্যাঁ এটা দেখি ওটা রিলিজ করো yes
My lord, I am being led by Mr. Lakman. He is appealing.
oh she was asking for he's there yes right
Yes.
Yes. My lord, may I only today pray for not today, my lord, would it be
yes
please
yes.
possible?
Yes it was paid for in the morning we said that we'll call the matter and then well
I'm so grateful.
on the prayer of the appellants the matter is adjourned for the day adjourned for the day means tomorrow it appears
Your Lordship, item number 12 also Rachit Lakhmani is appearing.
Mr. Lakmani, you are troubling the court like anything. You are asking adjournment on your own behalf. She's asking on your behalf. What is happening? You are avoiding the court.
My lord, may I? No, my lord.
Achha, very well.
My
Adjourn
lord,
for the day
in
na kore
item 7,
adjourn.
my lord, I'm praying for an adjournment.
Na adjourn till
Item
August
7, my lord, I'm praying for an adjournment.
August 3, 2026. 3rd of Monday.
Great.
One thing, my lord, may I pray, my lord? My lord,
Yes.
could it be on any day after Monday? My lord, Monday I have some difficulty. I'm opposing Mr. Lakhwani, my lord, although I don't have a right of audience, but my lord, I'm on the caveat if they
Monday
press
you have some difficulty. Monday you said you have difficulty.
My lord, Monday, my lord.
So we are keeping it on Tuesday, no difficulty. Then আগের matter আগের order adjourn till August 4th, 2026. Tuesday.
Grateful. Grateful.
Thanks.
Grateful.
Yes, Mr. Tewari, what is it? Yes,
So
yes.
defects are concerned, Lord, name of the judges of trial court, name of the respondent.
Curable by you or
Yes, curable.
has to be sent down?
No, it curable.
Curable by you. Then we are granting you leave to do that.
Yes, yes.
Well, the spelling and all.
Yes.
Leave is granted to the learned advocate for the advocate on record for the appellants to carry out the necessary amendments to the memorandum of appeal in order to cure the defects pointed out by the stamp reporter during the course of the day. You are the advocate?
Yes, ma'am.
Well, yes. No, Rajlokhi Ghotok is there. Is she there?
Yes, yes.
No, you are there. You are there. You do it.
Trial copy, certificate copy যেটা পাওয়া হয়নি এখন।
No, trial court certificate copy is not available till now.
Trial court
certificate copy is not available.
Oh, that defect is also there.
Yeah. The trial court certificate
It
copy
is a second appeal.
Second appeal.
However, since the certified copy of the judgment and degree both
lower court bill.
judgments and certified copies of the judgment and degree of the trial court are not yet on record, leave is granted to the appellants to file the same within a week.
Within a week or 2 months.
Within a week from date, footstep let the matter be listed next on August 10, 2026.
Yeah.
Yes, you are for the respondent.
Respondent number 2 and 3. Mila,
When?
saying time for to file opposition of section 5 application. Mila.
Section 5. How many days delay?
29 days.
Sir, 29 days. What opposition? Forget opposition.
My ground is that, my lord, by
How can you have personal knowledge? Your client has personal knowledge of their averments. They have pleaded that. What is your ground? Legal advice on does your client know about whether they obtained legal advice? You cannot have any direct knowledge of this. How can you prefer an opposition?
I'm praying for not to do, my lord.
That is also refused. Why should we grant?
Yeah, my lord.
Mr. Ghosh is there somehow involved in this.
That's one.
No. Section 5. No, we are not granting it.
My ground is not that by wrong legal advice, not 227 was filed against an order rejecting my application for temporary injunction. So, we have filed.
That is not bona fide.
After that, the certificate copy was filed. Then after getting proper advice, my lord, we have not obtained certificate copy and not filed this.
29 days delay. What is the question? Don't make the face like that. Yeah. Yes, no, we are allowing this section. This is against injunction.
Refusal of injunction. Partition suit.
Well, Mr. Banerjee, let us keep it and she'll be embarrassed before a senior, because in these sort of matters we may decide the appeal itself. We don't know. Section 5, then appeal, and maybe affidavit of service filed today be kept on record. An adjournment is sought by the respondents. Push up next para. Although the respondents seek leave to file an affidavit in opposition to the condonation application, comma, no such leave is necessary, comma, in view of it not being possible for the respondents to have direct knowledge of the facts pleaded in the condonation application. Push up next para. Let the, however, comma, on the period of the respondents, comma, let the matter stand adjourned till August 3, 2026. Thanks. Come back on Monday. You come prepared if your senior is not there. You have to come. You are appearing in this man. You said you are not in this man.
No. They are appearing on respondent
2 and 3.
আচ্ছা যেখানে যেখানে রেসপন্ডেন্ট বলছি রেসপন্ডেন্ট নাম্বার 2 and 3 করে yes yes Mr. Banerjee.
But against the refusal of injunction order, my lord.
Ad interim or
ad interim. My lord, may I only point out one fact, my lord. Against one of the suit value is 35 lakhs and odd. 36 lakhs and odd. My lord, I preferred, my lord, suit ad interim was dismissed. Not allowed, rejected. Against that, my lord, miscellaneous application was initially misappeal was initially preferred. And the learned appellate court, my lord, rejected my miscellaneous my misappeal on merits, not on the ground of maintainability.
Did not have pecuniary jurisdiction.
No, could not have been.
Well, you invited this?
Yes, I invited, my lord. That was on a wrong advice, but my lord, not on the ground of maintainability, my lord. But my lord,
on the merits, what has been held. We also have to be satisfied on the
yes,
merits.
Certainly. I'll come to that.
We'll take that point as one of the grounds, but
my lord, I'm not, my lord, I'm not pressing that down, because the learned appellate court should not have nothing to do with this. I invited learned
understand. We understand, but independently on merit satisfy us.
Yes, certainly.
You have challenged the main order now before us.
Yes, the main order.
Oh, but that order still, very well.
That is why, my lord, I talked to some seniors as well, my lord, whether to prefer the revisional application or
whether to prefer both, actually. 227 against that and this. Independently. Ideally, you should have preferred both. And we could have tagged that 227 along with this. Classically, that should have been done. Does it become a nullity? We have some doubt. Lack of pecuniary jurisdiction, that point was, there was no scope for them taking the point.
No. Had it been, my lord, dismissed on the ground of maintainability, my lord,
then no,
there would have been no bar.
Did not have challenged that.
Would not have challenged.
Without jurisdiction. Pecuniary jurisdiction does not hit at the root of the matter. Mr. Banerjee, we should not advise you to do whatever. We'll take it up 1 week after. In the meantime, we challenge that order also. Challenge that mentioned before us.
Kindly, my lord, writes this line. Otherwise, my lord, I cannot be able to tag it.
We'll make it your prayer.
My prayer.
At the out,
only one thing, my lord, can the certified copy be dispensed with? Since, my lord, the certified copy is already there.
Very well. You file it as an application, interlocutory application in connection with the appeal, so that it comes to us directly. Make a prayer for setting aside that order. You make it a can to this appeal.
Yes.
Make it a can to this appeal.
I'm not only inquiring whether the certified copy of the appellate court is already there. Yes, certainly. I will wait.
At the outset, comma, learned counsel appearing for the appellants, comma, in his usual fairness, comma, points out that although the learned, although initially a miscellaneous appeal was preferred against the order which has been impugned in the present miscellaneous appeal, comma, before the concerned district court, comma, the same was dismissed not only on the ground of lack of pecuniary jurisdiction, but also on the merits of the case. It is submitted that since there was, since the district court had no jurisdiction to adjudicate on the merits of the matter, after having, it was also held that he does not have pecuniary jurisdiction.
No, the point of pecuniary jurisdiction was not taken by any of the parties. No, but they were not. They were absent. Was not taken up by me and the learned district judge, the district court, my lord, came to the
কি
conclusion that
বললাম একটুখানি
load merits.
শুভ্র আমাকে বলো although
It is submitted that this court had no jurisdiction to adjudicate.
this court the state
It
court
is submitted that since the district court had no jurisdiction.
না this court কেন বলছো
The district court had no jurisdiction to adjudicate on the basis of the matter after having
merits of the matter, comma, the the said order is a nullity and as such has not been separately challenged. Full stop. Next para, however, comma, during arguments, comma, this court is of the opinion that for the sake of propriety, comma, since the earlier appeal was dismissed not on the ground of maintainability but on merits, comma, a challenge has to be preferred against the same. Full stop. Next para. Even if we ultimately arrive at the conclusion that the order of the earlier appeal was bad due to the appellate court not having pecuniary jurisdiction, comma, there is some doubt as to whether the said lack of jurisdiction hits at the root of the order of the district judge, comma, rendering it a nullity altogether, or the order is still required to be challenged. Next para. Upon this, comma, learned counsel for the appellants, comma, for abundant caution, comma, seeks leave to prefer an application in connection with the present appeal, assailing the order passed by the earlier court. Next para. Accordingly, comma, we grant leave to the we grant such leave to the appellant to file an application for appropriate orders. This is one of the cases where appropriate for appropriate orders. Otherwise, the office will not take it.
Yes.
Appropriate orders, comma, in substance challenging the earlier order passed by the district court against the self-same impugned order, and to mention the same for being tagged along with the present file. Full stop. Let the matter be listed next on August 10, 2026. Full stop. In the meantime, such proposed application shall be filed. Full stop. We grant leave for such application to be filed without the certified copy of the order of the district court and stroke or the order of the trial court, comma, since both the said certified copies, comma, we are informed, comma, are a part of the
kindly, my lord, does not, my lord, dispense with it. Since, my lord, I have to, my lord, check the file, my lord, whether the appellate court order or the certified copy is annexed.
তাহলে is dispensed with যেটা বললাম তারপর কমা ওটা থাকবে, কমা দিয়ে since না করে in the event the same forms a part of the record of the present application, present appeal.
My lord, kindly, my lord, makes it 2 weeks. My lord, my client stays in Bhubaneswar. The practicing advocate there, my lord.
Date তাহলে August 17th August. When you mention, ask whoever mentions it, please mention that the appeal itself has been directed to be listed on such and such date.
Yes,
It's in connection with that.
Grateful.
Otherwise, we may refuse.
Grateful.
Yes. Not really. আচ্ছা চল এক মিনিটে কিছু পাবো হয়ে গেছে এক মিনিট we are not sitting up in the second half because my learned brother has another bench with a different